individual also paid. But in the present petition, the petition.
Hey, give me that, file.
So one. But in the present, telling us the order on the Annex 1 that is based 30 my lord.
Thanks. Yes, Annexure 1.
Annex 1 page 30 my lord, wherever the executive engineer Kendrapada has my lord imposed a penal amount of 9 lakhs on the ground of delaying execution of the contract work.
Yes.
But the
Was there any terms and conditions in this regard?
Malad, there was a term for extension of time and the delay occurred Malad, in the month of March 2020.
That is what a subjective satisfaction of the authority. Now, question is whether they were empowered to impose any penalty or not. That is what is the first
They
question.
have the power to impose penalty.
Correct.
But
Now you have asked for extension.
I had asked for extension.
Have they awarded, have they granted extension?
They have not responded to it, Malad.
Hasn't responded.
So, the delay caused in the month of March 2020 when COVID was at its peak and there was a lockdown.
Are you taking shelter under the force majeure clause?
Malad,
Is there any force majeure clause?
Only there was a clause in the tender document for extension of time. If
I am talking about the force majeure clause.
that force majeure clause was not there in the
Is not there.
contract manner,
So-
so you kindly visualize, my lord. They could have extended. You also kindly come to page 37. Page 37, my lord. The last clause, extension of time, clause 4.
Yes.
But if the contractor shall desire an extension.
What is your reaction to it?
My lord, this repetition is premature, my lord. Let's say kindly have
Why
a glance-
premature?
My lord, let's say kindly have a glance to paragraph 23 of the repetition, page 24, my lord. Towards the middle,
Yes.
the sentence starting from arch for, my lord. The sentence starting from
As per
arch
clause
for.
9.
Yes, my lord.
As per clause 9 of the information.
Yes, my lord. They say
Yes.
that if the first authority has passes any order and that is goes against him, they have to approve before the appropriate authority, and they have annexed some documents, my lord, that they have approved before the government.
So there is no arbitration clause.
There is no arbitration
No
clause,
advice, sir, no.
and they have attached the documents. Let's say kindly have a glance to Annexer 17 series and Annexer 18 series, my lord.
Page.
Particularly, my lord,
That start from page 7.
So, as is presentation.
yes, my lord, and Annexer 18, it's at page 6, my lord. They have challenged this order.
47. There is a IO in between. That's why I am thinking.
Page 8.
Contempt. Page.
86.
Starts from page 78 and it's a 17 series. I have approached the authorities.
That starts at 86. Appropriate page is at 87.
87.
Yes.
My lord.
My lord, they have challenged this order under Annexure 1 before the government. When they have filed this application challenging Annexure 1, my lord, now their prayer is to pass the Annexure 1.
My lord, I have approached this Honorable Court. My lord, why I have challenged this order in order before your on this honorable court, my lord, because this order was passed.
Ground for challenging that order imposing penalty.
My lord, your also that's your also kindly come to that extension of time clause, my lord.
Correct. Now, first tell me,
My lord.
what is the meaning of the word extension?
For extension of time, if it cannot be executed
Now,
due to situations beyond control of the contractor.
when a person asks for extension,
But if he fails to execute the work within time,
there should be a time principles that should apply.
Manoj,
The if the contract was up to a particular period,
Manoj,
and you know it that there was certain, there was certain lapse, I would say obstacles that could not make you to execute. Then what is expected from a reasonable man? You apply for extension before the original period expires.
before the original period
So,
expired.
sir, the order was of November 2023. We
Right.
asked for an extension in the month of June 2024.
No, but prior to that, my lord,
6 or 7 months.
no, my prior to that I had,
The order of penalty was already imposed on you.
no, my lord,
Is
prior
it
to
not
that,
an afterthought application for extension of?
my lord, prior to that I had, your lordship
That you have
on the
asked for.
reopening day of the lockdown, my lord, your lordship,
I
and
have- You just shown that.
page 63, your lordship, kindly, page
before the
63,
period.
your lordship, page 63,
From your data.
on 15.
Demonstrate from your data.
My lord,
After these two.
That's, that's not, that date is not there. So that is there. My lord,
Yes.
15/4/2020, my lord, that is there, my lord. The request was made for extension of time. So lordship,
For 3 months.
but they did
3
not,
months was expired in 15/7.
thereafter continuously I have been making, my lord. Your lordship, in the 2021, my lord, I have also, continuously I have been requesting them for extension of time, your lordship.
To go, you have already gone, let them take a decision. That is not an automatic one. Let them take a decision, otherwise you can't.
Because my ground for praying
There is
extension,
this clause, paragraph 23, you just told.
Yes.
Clause 9,
was being there, my lord.
where do I get?
My lord,
No, it is not.
No.
Where is the power for extension?
your lordship, power for extension is that I was facing to your lordship, my lords.
There is a clause.
But the clause is, my lord, you also may come to page 37, my lord.
Yes.
Last paragraph, my lord, extension of time. Clause 4, if the contractor shall desire an extension,
Yes.
my lords.
So this clause 4
My lord.
is there. And what was the original tenure or duration of a contract?
Your lordship, that they have reflected in the input order.
Where it is?
Your lordship may kindly
That
come to,
expires.
my lord, it commences from, my lord, 7th January 2020, my lord.
Yeah.
Your lordship may come to page 30 in the input order.
Where- that's good.
It was to expire on 6/4/2020, my lord.
6/4/2020.
20, my lord.
And your first extension was
On, my lord, 15/4, my lord.
after the period.
My lords, they have said that 30 days, your lordship, under clause 4, they have said that there shall,
30 days, I have seen.
my lords. So, after the COVID lockdown, my lord, lockdown was lifted on 14th. So the very next day, my lord, the very next day I have applied for the extension of time, my lord.
What it say?
Well, at the imperial orders that my lord, he could not come.
Now this was the period
Yes, my lord.
and there was a little movement. I think there was practically no movement.
Yes.
Particularly
April 2020.
what can be?
Now, my lord, the crop
Came, I think in the 19th or 20th of March.
it is in the month of March, my lord.
Lockdown was imposed in the month of March, 2020.
That was 19th March or
21st March.
21st.
In the state
21st March.
In April, complete shutdown,
Completion.
complete shutdown,
Actually, there was a complete shutdown.
whole of the month. Then May gradually
Expensive.
started.
So
My lord, so far this annexure 9 is concerned, my lord, I have to take instruction on that, whether they have. Yes, my lord, we have to.
You have authority to impose, but yes, that time you have.
Yes, sir.
Some kind of a relaxation.
But
it appears that so far as the quantum of work which he has undertaken is less than the 50% of the total amount of the work.
Yes, my lord.
But as per the my lord, conditions of tender, my lord, they should have gone paying the running bills, but they have not paid the running bills for a month of for a period of 1 year, my lord. That's why the subsequent was.
When you entered into a contract, then why you did not raise that point? You were not supposed to do that.
Well,
You have to complete the work. Like whatever resources you have.
periodically it has to
It
be
does
paid.
not depend upon the payment date. The date of payment you are entitled to, not kind of a compulsory. But that does not mean that you will stop the work using that.
But in the absence of the extension of time, I could not proceed, my lord.
Sir, extension was for what period? It was definitely for 1 month, and it appears that you have done only 30%, less than 50% work. They have indicated that you have done some work of 20 lakhs and all,
March.
maybe 48 lakhs and all. That means less than 80%.
That was because, my lord,
So means
they did not extend the time so that I could not.
that does not, your substantial work, you had a substantial time. In your, the contract started when.
When I started in January, 7th January
From
2020.
January to March, you could do only 20. What do you expect? Within 1 month, you will do 48 lakhs rupees work.
Your lordship may kindly come.
For 3 months, you could do only 20 lakhs work, 1 rupees, 20 lakhs. You will expect that within a month, and there will be no lockdown, you will complete 48, the 148 lakhs. Is it believable?
Your lordship kindly come to page 53. There are stages of works, my lords. The stages of works.
What stages
Your
now?
lordship may kindly come to page 53, my lord. Scope of work and stage of payments, my lords.
50?
My lord, 53, my lords.
Yes.
Your lordship, scope of work and stages of payments, my lords. The different stages of works, my lords. So once they have not extended the time for extension of second stage, my lord, so thereafter I could not go to the other stages, my lords. My lord, I had completed the first stage within time, even before time, my lord. Thereafter, the COVID situation started, and I could not complete the second stage of work within time. So since the second stage, after the second stage of work, no extension was granted, my lord, I could not proceed further for the third, fourth, and fifth stages of works.
And it's also that, in each stage, they have to come and measure and, take amount of that, thereafter release the funds and you.
No, not, my lord, the nature of, my lord, there was no construction work involved, my lord. You will also kindly see, this is a consultancy work, my lord.
This one you just taking short.
Yes, sir.
What will you do?
They are not responding.
What's it right over?
Yes, sir. I will take this.
You have an authority, you could have said one stage,
Yes.
because there has been a deliberate delay on your part, you can understand. But you can't just keep mum and then go on invoking whatever the provisions are there.
Yes. But it is right. only one thing, Millard, they're showing annexure 9, Millard. Let's see, may see annexure 10. Millard, in annexure 10, that is an endorsement of receiving that document, but this document under annexure 1, annexure 9, Millard, there is nothing, Millard. On that point, I have to take this. Note.
Even though it is in May, and 2020.
Yes.
Just after.
Yes, that I will take.
So one cannot be sealed because that was sent to email. In April 2020, there was complete lockdown. There was no person working in the office. She sent to emails.
It's on the email. This is rehabilitation In this act. matter, in this matter, Millard, that's it directed us to file an affidavit, Millard, so first reply. Because
Also distress.
Yes, Millard.
Then what more,
Nothing more, Millard.
the.
We are in the process of complying that order, Millard. We have filed
This
this.
is not, this does not absolve you
Minor.
from your responsibility or absolve you from the clutches of the contract.
Let's see, that's why directed us to file a so-called reply, Millard. We have filed it this morning, Millard. Let's make Columns matter tomorrow.
It's not satisfactory then.
Let's make
Copy
Columns matter.
has been given.
Yes, I'm giving the copy because we have filed it this morning.
My lord directed that it is to be after dismissal of SLP, nothing remains to interpret further. Till then, they are filing an affidavit.
They are giving an explanation probably that this is not a contemptuous act. We are in contempt jurisdiction.
My lord.
Correct. We have to see two things. One is whether their conduct is contemptuous. Inviting, them to be punished under the contempt of court.
Yes, sir.
Second thing is the implementation of the law. These are the two facets we have to see.
Yes, sir.
We will be filing an affidavit so far as conduct is concerned.
Like, we will have taken up next week.
You give them a copy.
Thank you.
Give them a copy. You want more? You want more or not?
No, Millard, that's not common.
Affidavit.
Right.
Affidavit today is not filed.
Yes,
Already filed.
yes,
Only registered.
yes.
How many containers?
Only 1 minute.
One. But
This order was passed.
Order has been, you wanted to cross the order,
No,
that was caused.
no, I wanted my entire,
Why you are so much, banking upon a Tehsildar to do it?
because my lord may kindly to page
Now
80.
Tehsildar has no jurisdiction, what to do?
My lord may kindly see page 88. Now, what will be the situation?
Yeah, I'm asking you a very simple question.
Yes,
I have come across with these kind of situations. Before the tribunalization happened, the writ petitions were pending before the court. Everybody knows. Now there is a tribunal which is set up. And the order says that all have to be translated, including an application for review.
yes.
What would happen? After we decide the judgment passed by the High Court in review.
Here the facts are little different. That is
I'm
why,
asking this. The question was that whether it should be individual. It says all application which includes the review application and filing. So there is no difficulty when the jurisdiction is vested. Then in that event, the authority cannot reserve the jurisdiction.
no, here my lord, the facts are little different. That's why I'm placing them. Here, my lord may kindly see prior to, because here the question,
Tehsildar, after the amendment, ceases to have any power so far as the mining members, mining members of the mining members of.
Yes.
Now question is that whether he can relate.
he, the Tahsildar raised the demand for 22-23 in February 2025. Prior to 1 year of, in February 2024, for the self-same period, mining officer OP number 4 raised the demand for 22-23. I paid that demand. Then for 23-24 and 24-25, mining officer raised the demand. I paid that. Now after 1 year, Tahsildar raises the demand.
Paused it.
No, that demand has not been passed.
We have paused it.
So that,
We say that the mining officer will take charge. Now mining officer will say, I have already taken a decision. Let him take a decision.
no, that demand has not been passed, raised by the Tahsildar.
Sir, you wanted this application for you challenge this.
No, I,
2025.
no, I also challenged the demand on 30th. On
That passed by the Tehsildar is likely to be paused. 22/4/2025 is the order of the Tehsildar
prior to that.
raising a demand.
No, that is not the demand. That is why.
Then what
The
is
demand-
the demand?
Demand is 5/2/2025.
Correct. Did you challenge the demand in your writ petition?
Yes, yes.
Where?
Prayer number 4, page 60, madam.
Page
60. Prayer number, page 60, prayer 3, madam. And as to why. Letter,
propose as to why the first prayer is.
yes.
Why the order dated 22/4/2025 is not passed.
Yes.
Then why cannot be delivered, should not be directed to deliver a recent order on an application using 4/3/2025. Third prayer is to refund the excess amount.
Yes.
Fourth prayer is,
This is the demand.
I am asking,
And as
or
to,
to successor shall not be caused.
Yes.
Correct.
that is page
The
1.
court, the
Yes.
court found that this is not expected. And then granted you a first and secondary. Granted you a first and secondary. That means the court has denied to enter into disaster. So far as the other prayer is concerned, does the review lie? I'm asking you a very pure question also. Don't go in a fact. If there are 5 prayers made in a petition and the court granted 2 prayers, what does logically follow in law? That the court has refused to interfere the other 3 prayers. Why review?
No, because by virtue of the directions contained in paragraph 10.
Let them go and decide, filing officer, we have given, he may recall the order, he may do whatever he likes. It may be a erroneous order, but it is not an order which is according to the physical record.
22, 23, then 23, 24 and 24, 25.
So he has filed an application for legal situation of that.
That is also not representation also.
No, no, in the representation, no, in the representation also I have stated to the Tahsildar that since the demand has already been raised by the,
He will take it to consideration.
no, my apprehension is
So here, can review my application.
he will review all these demands.
He say, can he, you know the scope of review?
Yes.
Observation that
You are inviting us to make the observation that we have refused these three prayers. Will it do for you? Tell me. So we have to say, review does not lie. Undavardhana judgment of the Supreme Court, yeah, 1960 Supreme Court. What do we are stuck with this judgment of a larger range.
No, only my apprehension is so far as if before can review the full review.
I am asking to read that judgment, what the Supreme Court has said. And secondly, in the guise of a finance, you are seeking a review. But you really intended to have a clarification. Is it fun? You are seeking for a clarification, not review. Tell me, sir. I know we just converse judgment of the Supreme Court. I think this situation covers both. Supreme Court says that in the garb of clarification or a modification of the order, you cannot seek review.
Kamlesh Verma.
there.
That university matter is also there.
At page 95, it's a, therefore, there remains nothing to explain the system of the secondary.
Judgments your lordship is referring to. Judgment.
Below that.
Kamlesh Verma and A.S. Bopanna. The other one is Sanjay Kumar Agarwal. This is the latest judgment of 2023. On the question of maintainability of the review, under what circumstances the review can be attended and cannot.
Kamlesh Verma is clear.
Now following first.
What do we can be taken out from 1.7 to 1? So. We have to make observation.
Only my lord may grant me liberty. If any adverse order is passed by the OP4, I can approach this. Only that liberty, my lord.
In the review. Or. How do you go on this? Sir, if you have a statutory right, no liberty is required from the court to exercise statutory. Why? The statute has provided you a right. You exercise it. Why the leave of the court is required?
Yes, may grant me liberty to withdraw the.
Wants to withdraw this.
Yes. Yes. Why?
I will give the memo.
61 Supreme Court plus one.
No, it was earlier, yeah.
Permitted to withdraw the method.
Already, no interim order. Now the Odisha Real Estate Regulatory Authority functioning. I have copy. 3. Mel.
The chairman and the members have
Already
been
appointed.
appointed. Yes.
Mel. Mel.
For the presence.
Yes, yes. Mel.
Item 5 is behind for construction of Cyclone, multipurpose Cyclone Center. District of Jagasin.
If that matter will have received directed us to cooperate instruction will have, we have filed an affidavit to that effect. The government has taken a decision on 13/3/2025 for construction of all these multi-purpose cyclone shelters Miller. And the cyclone center in the village of the petitioner, that is also included in that proposal Miller.
The intention is that from 2021 it is under.
Disasters.
Yes. Yes.
Oh.
Yes, ma'am. Let's see if I carry it on to page 10.
No, sir. For development.
Yes, please.
Where is that?
At page 10, Miller, that is the minutes of the meeting.
I am asking, I thought four of the order dated 8/8.
Miller, Miller, that is already paid.
You don't get that to a right hand.
Yes, Miller, that is, yes, already deposited.
For benevolent purpose.
Yes.
How? I mean, the deal of that.
Yes,
Agency.
Deposit version.
Industrial management agency.
Hey, how can, you can't deal with that.
OSD elements.
Just to
Disaster
management.
management.
Wait.
Agency. Agency.
Even if, even cash, I'm just asking.
Authority and everything. Authority.
To have deposited. Oh, the authority, Miller, that at DTS.
I can understand. But not nobody needs that. It coming from the treasury of the land.
Yes.
C is also already agreed.
Yes, correct. It's obsolete.
Where is the decision?
And from consideration, but implementation is not that much. That's written in
No.
The language is very, I would say.
Yes.
Was given you that proposal and what is the time limit for carrying out the session?
No, there is no proposal. I mean, say the proposal is under consideration.
Merit, the proposal is given by the district collector. Now that proposal is part of this constitution.
Where is that document? Where is that?
Merit, they have not provided the document, but it is
Where is that?
the proposal of the collector.
In village included.
No, that
Yes.
is one thing. One is the proposal and another is the conscious decision on the garbage. We are more concerned with the decision of the government to set up the
Yes.
cyclone.
Yes.
The shelters.
Let's see, annexure 11 and annexure 12 mirrors of the writ petition.
Yes.
That was the
These are the letters.
letters of the collector Miller.
I have, sir.
Let's see, please.
There is a proposal now, but whether this proposal and accepted or not, these are the statutory shape filter. And
Yes.
when our state is concerned, it is prone to cyclone.
Yes, ma'am. That is that lease Miller that is not filed and filed that.
The language of some
Paragraph 8 Miller. We'll file that list. Miller.
What? It is hardly submitted that the construction of multi-story cyclone center in the same village of the Odisha is in the
Proposal for
consideration.
Yes.
Is not taken a decision as yet.
Miller, we'll
We
file.
wanted a decision to be taken.
Yes, Miller. We'll file it.
Or if you want, we can dispose of by giving a balance. The question of consideration does not arise.
Miller, we'll clarify that. And I will file the list. Miller.
You have to be very careful when you draft.
We'll clarify that. Yes, yes.
Right?
The demand of additional charges of royalty is understanding. Additional charges of royalty is understanding. Additional charge,
This is charge of
royalty.
royalty.
Yes, ma'am. Madam, the fact of the case is that for a fan query, a tender was floated and I was the participant. I became the second highest.
Yes, ma'am. The first highest quoted rate is 121 per CM and my quoted rate is 76. But the first quoted rate highest is H1 bidder. He would have cancelled because he couldn't deposit the. Accordingly, I was intimated by the Tahsildar under annexure, there are lots to annexure payment. Page 10. On 3, that is approach to OMC rules 2016, option of the source on long-term lease basis for 5 years. That is 18 to 20 was conducted on 24/7/2017.
This is the episode of 2018.
Yes, madam. Madam, yes, that was not finalized. That was final. I was demanded to deposit the fees on 2024. I have deposited the fees.
Nearly amounting to rupees 33,000 within 7 days.
Yes, that was deposited. After depositing that is the next page, in 11 I have deposited that amount.
And then what?
Then thereafter, a public meeting was there and I was allowed to take a environment clearance. Environment clearance was page 4, no, annexure 4, starts from page 12. After taking the environment clearance,
24.
page 12, starts from page 12.
That is of 2024.
Yes, ma'am. After environment clearance, by the letter dated, the honorable to annexure 5. Annexure 5 at page 26. At page 26, my opinion was called for whether you come to the 121 rate of the first H bidder or not. Yes, that is page 26, annexure 5. Thereafter, I have given my consent in page 28, annexure 6, that I am agreed to pay that 121.
Then they say
Thereafter, he make a demand.
EMD of this amount.
Yes, ma'am. Then by the annexure 7, I was directed to deposit the amount.
Correct.
The system of deposit on page 30, on which account that will be deposited. There are 16 lakhs 62 rupees 59 that was deposited different accounts, and in view of the accounts given, I have deposited. The deposit slip starts from page 32, annexure 8. I have deposited the amount as demanded by the annexure. Thereafter, after depositing the amount, I made a request on 15/4/2025 to execute the agreement and to hand over the site. Thereafter, he make a demand on annexure 10 that the additional charges of 928 per cubic meter. That is annexure 10, page 37. After deposit the total fee, that's there.
Where is this letter of 21/4?
But that has been filed in the memo, that is 30, page 39 is there. Page 39, the memo has filed this letter.
21/4.
Yes, ma'am, that letter of the director. That was attached, but at the time of filing, in that question that was not filed, I have filed through a memo, and that was in page 39. In memo, I have filed. That the letter of the deputy director is yours. Only this letter is subject to execution of lease agreement in respect of Birupa River Sand, Bhairapur, Tahsil, Salehpur district contacts.
You have invited a tender.
Well, I understand, but they should not have, the director should not have.
What?
Yes. Yes, and when the provisions are absolutely clear, the lordship will look at 27(9). The provision is absolutely clear. The director should not have passed this order. But the additional charge cannot be buried.
Correct.
He has only to meet the additional charge by the H1 bidder.
Correct.
So that is the provision is also.
Negotiation.
Yes.
And he matched with them,
Yes,
and now it is really a.
928
more than-
should not happen.
More than the quoted price.
yes, it should not have.
Is it?
It should not have been, but because even while getting instruction from the authorities, I have also discussed with them. If your lordship will look at this 27.7 of the Odisha minor minerals. 27.9, your lordship may kindly.
No power for clearance on this.
No. 27.9 is clear. In the event of default of the selected bidder, the competent authority.
4/2025. I'm asking you, have you challenged? Have you amended the prayer?
Yes, sir.
Where?
Yes.
Where?
That has not been amended, only because that has annexed, I filed a memo that has not been amended. I have not
Where
amended.
is an annexure?
Annexed to 10, that is,
Where is an annexure?
annexed to 10, that is,
It's not, does not appear in
only for that purpose. The annexed to 10 is the communication to me. Not communicated. Yes, sir, I understood. I understood the problem.
Made in prayer to
Yes,
set aside a first that
yes,
particular
madam,
letter.
but that only because that letter, since that letter was not communicated to me, that is only the mining officer, and mining officer has communicated on 5/6 along with this letter. For that purpose, I have prayed that annexure 10 we first and 39, page 39, the letter is dated 24/1 is a part of the annexure 10. They only for that purpose.
Sir, it's an independent letter and 5/6 is a dependent order.
But I mean,
Are you aware?
I may allow.
You do not challenge the parent order and challenge only the dependent order. Then the writ is not
I
maintainable.
may be allowed to.
After letter order is passed.
Because this order of 5/6 is based upon 21.
Yes, but yes.
And you have not challenged the 21 .
That order was not given to me. I
Copy annexed, you are taking a plea argument.
No.
That since the copy was annexed,
Yes, ma'am.
then you had the copy of the order.
Yes, yes.
So when you can challenge 5/6, you can challenge 21/4 as well.
I will be allowed. I'm allowed.
orders. And you want to have challenges with that. Yeah.
Concern, having supplied free school feed to different ICDS project through a bidding process. On the last category, oxygen directed to take instruction regarding the payment.
But, the counter affidavit filed by OP number 3, that prima facie is was filed on 25/8/2025. Three is the
OP number 3 is the
District Social Welfare Officer, Burger,
DSW. Yes.
DSW. So Lordship will look at the,
The director.
Yes, sir.
yes,
Yes, ma'am.
annexure E/3 of that counter affidavit, page 16, if your Lordship will see that he has specifically stated that the equipments and other things have been supplied by the petitioner. And for that, a sum of rupees 2,13,000, the 13 lakhs 10,000 has been submitted to the authorities for release of the bids.
Right has not been denied,
Yes,
but because of the disbursement of the amount, payment is not made.
yes. But only I'll take up the issue with the government. If your Lordship may grant me some time, because it's very specific. E/3 is very specific. They cannot wriggle out of the situation. That is,
Then in fact, we are interest also for unreasonably withholding of the amount.
let me just,
This is the legitimate claim.
yes.
Deny a legitimate claim.
But
Appreciating by the quality of the materials he supplies was not appropriate or up to the mark.
but they have said that the fund that was there,
It
has lapsed subsequently. And a fund was there, but subsequently it lapsed because of delay in delay in furnishing those articles, my lord. Yes, 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 he has delayed one. He has delayed one. There was a delay for which, but subsequent, yes,
The government take away the allotted fund from the PFMS account.
yes,
Now, due to non-availability of the fund, we are unable to transfer fund to the vendor in time. As the vendor has already supplied and completed all
Yes.
CDS project up to 2031. So a sum of rupees is required. So there is no allegation in this.
no, there is no allegation, but other communications which are enclosed to the affidavit, if your lordship will see.
If you do not
Yes.
see the payment,
Yes, no, payment has to be done, my lord. I cannot say that in view of this annexure E/3, there is absolutely no dispute. The payment has to be made. But you may grant me some time to take up the issue with the government, because this letter has been addressed to the government, additional secretary to the government. You may grant me 3 weeks time.
there is no delay, actually. Yes, the black materials, the already black issue that there has been some damage which
Which was
replaced, which he replaced,
Yes.
then what more?
Your lordship will look at annexure A/3. A/3, your lordship may kindly see.
Sir,
Yes.
last sentence.
If you will failure to distribute the materials, district office shall not be held responsible for
No, sir, not me.
annexure A/3.
By first paragraph, last sentence.
For a moment, if your lordship you have a glance to A/3, my lord, A/3, for a moment, my lord, page 12. With reference to our previous order regarding the supply of student chair, student table, water filter, so and so, it has been mentioned to complete the delivery within 20 days. However, we observe that the supply has not been completed till day. If you will failure to distribute the material, district office shall not be held responsible. That is what was communication. Yes, subsequently we have accepted.
After then, first of that. What is that? So, the transaction would not be completed at the transfer.
Yes,
That is, that your,
yes.
not.
Not attributable to him, because in view of E/3, there is no, I cannot say that further fault has occurred on part of the petition.
Well,
And
attribute. Correct. You are relating you to the opinion.
in terms of E/3, let me just have a, I'll take up with the government. If the lordship may grant me 2 weeks time, I'll just,
Well,
because this letter has been addressed. Yes, this has been addressed to the additional secretary to the government. Let me just, the lordship may grant me 2 weeks, I'll just.
The person who has supplied the
Tender for petition under 6 million. The petition is the highest measure. And they have deposited, he has deposited 1,15,000 to bid amount. Thereafter, they have not issued the work order in favor of the petitioner. Thereafter, he has filed it.
I can't believe that it's a citizen.
So what is, so it is the vernacular, my lord. That is, I've stated that.
You can read the, I can understand.
Yes, ma'am.
You can read it slowly.
प्रकल्प निर्देशक जल विभाजिका कार्यालय ढेंकानाल
Slowly, slowly.
नीला विज्ञापन संख्या 1319 dated 28/6/2020. Yes, my lord. Old and damaged vehicle. Old and damaged the equal purpose for removal of the. Yes,
From the project of.
yes.
Of water,
Water shed, my lord.
water is.
All the above,
Water resource,
yes,
the department.
yes. Accordingly. Thereafter, I have.
This is under soil conservation,
Yes.
soil conservation department.
We have
Yes.
cancelled Annexure 8, my lords.
Annexure 7, I'm coming. Annexure 7, I made a representation before the authority. Since I am the highest bidder, I have already deposited the amount.
Have they cancelled you?
Yes, Annexure 8, after receipt my representation, on the very same date, they have cancelled. Annexure 8.
That is from. What right, near.
Like whatever ground,
Highest bidder, does it create any enforceable right?
I have deposited the, they have accepted.
Reverse the judgment, I know the judgment reverse. You can, only a judgment is. In your favor, we are ready.
You- The lordship can visualize. On 30th/6, I have deposited the amount. They have,
To refund you.
No, that is-
With interest.
That is mentioned in the letter, my lords.
Refund with interest. Or receive.
Yes, my
From the
lords.
office.
Yes, my lords.
Who is
it is the afterthought, my lords. Your lordship can visualize.
I am asking, sir, I am on a very basic legal aspect. Whether a person who is declared as the highest bidder has any legally enforceable right to command the authority to issue a work order.
No, your lordship, that is true, my lord. Your lordship, that is true. Your grounds, they have, what they have taken. Well.
Legally enforceable right, then come forward and say cancellation. They are not interested in removal. Maybe.
No, that is not the ground. Ground is stated that the two members are not present. The very,
The people not constituted. No.
We have members to be can, on that.
Oh.
how they have accepted the bid amount, the final amount.
The wrong, they have committed.
My submission was that they have participated and the final
Sir, I understand you go and take back the money when you deposited EFT.
on 30th/6, my lord. 30th.
What, sir?
And in cash in the office.
Cash,
Yes,
30th
June, my lord.
June,
Right.
and they are given on 11th of July.
Yes. On my representation, not that so much they have given, my. On my representation, they have rejected. Annexure 7 is my representation. On the very same date, it has been cancelled.
So, well.
My lords, those judgments I have, my lord.
But I am not disputing that, by the way. I am not,
What legal right to have?
Para 32,
Yes, sir.
they are ready
You
to,
are- you are
they are ready
coming
to,
for the court of law.
they are ready to refund my, I am not.
If the law is against you, get the court is not your will.
With the liberty of lordship, my money will be refunded.
Absolutely, they have to. And it is in a very close proximity of time, so I'm not granting any interest on them. Because 30th June you deposited, 11th of July, they say any day you come and collect your money. And you are not going there. That is that.
Only my solution is because it is after thought my little on my representation, they have rejected.
It will be against the representation theory or the motion. It will be against that. If you have a legal right, your right is there. You do not have representation between the matter aligned.
No, my submission was I have made an application to issue a card. Thereafter, they have cancelled.
That's true. Even though, that's all, although the
File counter.
Item 9, your lordship, the last order, 6/8/2025.
Yes.
Similar issue in identical cases have been decided. Same clause which was in the challenge that was not disclosed, so you know, take note of that. Your lordship also directed to proceed with the tender. And today's instruction is they have already opened the financial bill. They are waiting for the government approval.
Already.
Counter.
What?
Let them file counter.
No matter. What we change the.
We one thing, kindly take this matter tomorrow. My senior will have this matter. Mr. B.S. Tripathi. Mr. B.S. Tripathi. Yes, please. And there's some, yes, ma'am. He has some difficulty, that's why we.
This matter or difficulty for the.
He's already left the court, ma'am. Yes, ma'am.
But in item 10, my lord, there was a direction to file counter affidavit. But I'm asking for a short adjournment. It is ready, my lord. Short adjournment which will be filed before the next. The counter affidavit will file, my lord, will require a little time, my lord. It is almost ready, my lord. We will file it.
Call it next week or?
After 2 weeks, 2 weeks.
2 weeks.
Let's may I pray for some more time without maybe the next.
September.
Because I have already studied that on the last. End of notice located by the Kotak Municipal Corporation. They are accepted as.
I have appealed for the purpose of.
Single,
I am for the successful bidder, my lord.
a single tender, my lord, which is provided by the government money. And next one.
Give us some time to file counter, my lord.
Government has made it clear, single tender cannot be accepted, but they are accepted single tender. There is no wide publication, man.
Yes. No. Who is representing the housing and the urban development?
What department, my lord, I am there, my lord.
How can you, there is a legal policy by the department that you can't proceed for a simple bill.
Well, like instead of only short date. Short date in the meantime, I'll take.
Have you seen that particular initial one?
Yes.
Yes.
To all the information, do not accept any single bidding.
And have launched the second clause, your lordship, clause 2. In case of municipalities and NSCs, the single tender proposal may be accepted by a committee constituted at district level under the chairmanship of collector and the other named.
Is there any?
Only to that effect, I will take a short date.
Committee constituted.
Yes,
before
yes,
the-
yes.
Before the tender is finalized.
Yes, your lordship, I will take instruction only to that.
So what you were doing for so long, this matter was taken up on that day last day. This annexure was a part of your petition. We do not ask for any explanation from them. You are referring clause 2. Will you not take an instruction?
So it was to do only short 3 to 4 days, I pray.
That's a difficulty. I should not make any.
No, no, lordship.
You should be more prepared, you should be more responsive, sir. When you know that you will be taking this plea before the court, will you not ask that whether there was any committee constituted under the district? If constituted, what is it was taken by the. That's the first responsibility of a lawyer.
My God.
Planning committee.
And
Lordship, only the
It's not in function of any paragraph 2.
that is why I only so that.
Not the particular was found.
Yeah, but instruction.
The clause 2 is for municipalities, not municipal corporation. I will give, sorry, my lord. Yes, yes, I understand.
We didn't, but the.
Big apologies, my lord, I will give you.
It is only
Yes, yes.
jurisdictional issue of
Sorry, my lord.
tender. The committee is to be constituted. Whether that committee
Not,
members are appropriately constituted or not.
yes, yes, well, that is what the clause 2 is not applicable.
That can be discerned from this document.
Yes, yes, ma'am. I have got clause 2 is for municipalities. For municipal corporation, clause 1 is applicable, my lord, not clause 2.
This is for the,
Municipal clause 2,
this is cut up
cut off municipal.
Lordship, cut.
from that. Paragraph.
Yes, that's the point. He says that it's a municipal corporation, not a municipality.
Yes.
Now, about clause 2 applies to you. Are you a municipal corporation or a municipality?
No, sorry, municipal corporation.
Then why not the who is applicable only in municipal corporation? And one is a complete bar, the bar which is created. Shall not be accepted. Therefore, the bar or will come.
Only I know. I have not taken lordship.
Even of excellent, exemplary,
Lordship. My lord.
For municipal permission, you are not able to-
No.
The serial-
Engage.
Then how you are appeal?
No, I have engaged in this case. They have given power, I have the caveat.
Ballot, I do not know, I have not seen the writ petition, just now I am going through the writ petition ballot because I am not aware of it. So only thing I know that previously corporation has been making attempt to issue tender notice, but no bidder was coming, and municipality is losing crores of rupees revenue because of this non-acceptance, and they are giving the job contract basis, they are giving to different persons without any tender. That is the reason why probably they have taken a decision to give it by tender only. For single tender and all that, that part may not have. That part, unless I know.
The circular of the order.
That must be. Because
They should have a clause that this is what is we are facing. We are not getting an adequate numbers of the bidders. Only the single bid is coming. So
Yes.
relax those conditions.
as-
It is within the powers of the government to, there is no difficult.
That part-
Your instructions.
No, well, it's,
totally, the
well, it's
municipality
I-
must have done it with some way. There might be something.
Granted cargo.
The corporation must have got something, but the lordship probably because of last week almost the government has also offices were also closed for the entire almost from Wednesday till Sunday. Government offices were also closed. That is the reason probably there is some my learned friend might have got difficulty to obtain these stations. So lordship is
If I may assist.
because that must be something. Corporation will not do it without.
Similar case with telling the exact same tender minutes, item 14 minutes.
Item 14.
But it's
On
answer,
what ground?
but it's the same ground, single tender.
This is same tender.
What you-
So, but my only assisting minutes query is that minutes suppose that single tender, why there is single tender minutes? As the fundamental is that when the tender conditions were not workable, that's the reason none of the bidders were participating. Just to answering my lord's query.
what is the wisdom of the
Balance,
government? To make the right conditions, which conditions have to be fulfilled. You can't dictate that whether
No.
those conditions.
Just assisting minutes.
Within their wisdom.
Balance.
So we got, but once there is an embargo, then how can I do? Unless they lift the embargo. Like in case of municipalities and what is this, NAC?
NAC.
Notified area councils. Where the population is less.
So they have to. What do you do? That is the remarks when one has to. You should have.
You are seeing also, but.
That
Well,
might be
same-
some the
Same tender, yes, or
Yes.
When the corporation has taken decision, there
Yes,
must
yes,
be
yes,
some
ma'am.
basis. Probably my learned friend has not, there must be some basis of that.
Mandate of the.
There might be some other document, I do not know, but that must be because otherwise, without this corporation would not have done it. Document, give this or date.
You will take instruction.
No. Only 1 week, actually, only 1 week.
Why not this week?
Thursday. Yes, sir.
Yes.
I'll let it come on Thursday.
Any other points?
no matter. No, that is point. Other points are therefore this is the matter. This is the point.
On this point, it's a six.
Yes. I will not go.
That is the,
My lord.
Minus. Yes, they're on David. Thank you.
Why is I'm also appearing? Says, yes.
Sir.
Well, let's
No,
take
it,
a file.
it,
14% soft copy during the course of the day.
Yes, sir.
Minus.
Noted, sir.
Well, it's, I think 14, state is not a party members.
It's municipality. Municipality.
But we will impose the answer by that reason. You have a question that.
No, that's the basis of,
Uh,
we have made a pleadings. Constitution has not happened. You're grateful.
That's me. I see order dated 22nd.
What's in the outcome?
Miller.
There is a manual.
Yes, Miller. Miller seconds.
Within 48 hours.
Yes, Miller, this is, let's see. Miller's there, I received instruction, Miller. This. Private OP number 7, they have written, Miller, that usual was beyond repair. So therefore, Miller. Yes, Miller, we have installed a new tube well. Yes, Miller, we have installed a new tube well. No. No.
They can't detect where to fall and where not.
No.
No problem. What do you mean?
Mahler, you will assume this was in the light of
Yes.
section Mahler.
entire writ petition, my lord, there is no abamment that there is any discrimination. In fact, my lord, they say this, my lords, they are saying, my lords, my lord,
The untouchability aspect has also been, when the point say that there are two words which is for the communal user and that too only for condition here.
no, my lord, what?
I'm addressing because Mr. Das, who is the counsel on record, right, his cousin brother expired today morning, so he had requested me, Mr. Das, who is on record. Lord Mr. is the Sanjay Das. No, my lord. After I discussed, after going through the petition, it's better to withdraw to approach the authorities subject to your lordship. I had also discussed with him. Because these are issues which are very limited. With the liberty, yes. I'll ask it because we don't have the power. It doesn't have the power, so I'll ask with the liberty to approach the authority. I know, my lords. The only problem is both of them have gone to the, like, for his last ride, so I'll just ask him to send somebody to, so that I can file it before the vote out and all.
This is a 180 ml matter, my lord. I've given a copy of your lordship's order. Corrected.
For restoration of the appeal, your lordship, for hearing on merit, your lordship. 20. It is an income tax, your lordship, the first appeal, the London Commissioner of Appeal has rejected the appeal on the ground of delay, your lordship. The first appellate authority has said that there is a delay of 886 days. It is income tax. No limit. 886 days has been found out, your lordship, by the first appellate authority. But in fact, it is a fact. The period with effect from that COVID period from 2020 to 2022, if that period will be deducted, your lordship, only 65 days delay is there. And for 65 days on the last occasion, the finding of the first appellate authority is that I have not enclosed any medical certificate along with affidavit, your lordship. I have submitted, but there is a miscommunication, and your lordship on the last occasion, your lordship was directed to submit the medical certificates, your lordship, in shape of additional affidavit. And I have submitted this through additional affidavit, your lordship, may kindly looked into. Your lordship, I have already sought the copy. In the additional affidavit, your lordship, paragraph 2, the managing director of the petitioner was under medical treatment from 12 December 16 to 18 June 2020, your lordship. So continuous medical treatment was there, your lordship. So for that reason, even the assessment was expired. Your lordship, on 11 December 2019, while I was suffering, the managing director was suffering, your lordship, the assessment has been completed expert, your lordship. And subsequently, the filing, the due date of filing was 11th January 2020. But 15th March 2020 to 28th March 2020, February 2022 is for the COVID extension, your lordship. So I have filed the appeal undated, your lordship, 14th June 2022. So there is a period of 65 days. Your lordship. 90 days. Your lordship.
That also you have received.
22nd June, your lordship, they have filed the appeal. And your lordship,
Another 20 days.
your lordship, only discretion, your lordship, so far as your lordship's view is only merit that should have been hard on merit, your lordship, only regarding only delay is there. Only your lordship, because there is a reasonable cause, your lordship, after COVID, he was suffering all along, your lordship, he was suffering from COVID,
The order was 11/12 from ND.
your lordship. The order was 11/12/2019. The appeal should have been filed as per 249(3).
And 122.
Your lordship, 10/1/2020.
It was not.
Not there. Your lordship, I was suffering. For that reason, I have stated that I was suffering all along that period through additional affidavit as well as before submitting medical certificate, your lordship. On 15th March, 28th March, then after 90 days, your lordship. And all along I was suffering. Only a discussion and the matter should have been hard on merit, your lordship. Only that reason. Limited grievance, your lordship.
Please say.
My lord, the assessment order was passed on 11 December 2019.
This confirmation of delay.
My lord, that is not covered. That period has been expired. That COVID period, pandemic COVID period, that starts from 15 March 2020. But here the appellant should file the appeal in 11th January 2000.
During January, January 2020.
My lord.
And disputing this,
No, my lord, it's going to be restored back. Because on that basis, the appellate authority has rejected, dismissed the appeal.
And the appellate
no-
authority's finding is that I have not submitted any medical prescription and affidavit, your lordship, at page 59. On the last occasion, your lordship has pointed out and also directed me asked me where is the medical certificate, your lordship. And accordingly, I have filed this additional affidavit that I have filed. Your lordship, only your lordship, only managing director. Your lordship knows in Odisha, in India, your lordship, suppose the once managing director is suffering. My lord knows also West Bengal also. Once managing director is not there, so. And your lordship,
outdoor.
your
You are never inpatient.
my impression with Villa. Your lordship, only I have submitted your lordship's order. So as a pragmatic approach, your lordship. Limited grievance only on hearing and merit, your lordship. Your lordship may fix a date, your lordship also, your lordship may direct a date that I can appear. Your lordship kindly looked into your lordship's order. Your lordship's order is also your lordship's order regarding pragmatic approach of this delay. I kindly looked into your lordship's order in another case. Only pragmatic approach.
20 kilometers.
Queen City, 20,
20 to 25
20.
kilometers.
25, within 25. Yeah, that's it. Yeah, that's it. Your Lordship, because which person is the office is residing at Bhubaneswar. Petitioner residing at Bhubaneswar. The office is at Bhubaneswar. Yes.
Lot of skin diseases, rashes that come. And he was taken care of by the skin hospital. And when you suddenly come to a product and you are private doctor.
Sometimes Your Lordship, these doctors
He never practiced with information. On the left side top.
Side not mentioned. Are you sure?
Well,
Separate of petitions.
they have not.
This finding of fire, have you sent off from your record of the authority?
So I'll take the instructions.
First class, you will try to agree.
One time, well.
First May 2020, we had passed one for.
Well.
Now we have to say.
yeah,
On your lordship is related to clubbing of multiple years in single notice.
Lordship, item 22, the Lordship was posed a question on the last date, Your Lordship. That's section 61, 65, 73, Your Lordship. In this case, I have received the instruction. Lordship, I need some one time for preparation, Your Lordship. Because this question of law has a larger impact. So, Your Lordship, some preparation. Your Lordship,
Not show you
No, no,
You have to
no,
find out the law.
no, I'm finding out, but so far as the modality, I have just called for the modality of the how the audit will be done, how the scrutiny will be done, all the modality parameters have been called for, and I have received. The last 4 days, it was holiday, I was out of station. So only for my sake, your lordship, for my preparation. And already I have undertaken that not to take any corrective action. Your lordship has orally directed, and I am continuing, your lordship. 1 week time, your lordship. Next week I am ready.
My friend has said that. I'm not standing on. No, let it be not. Only my friend has given the.
You should compliment him that you go and enjoy it.
Sir always inspired me to go.
I also go on vacation. I never.
Sir always searching the red line of the calendar. So when there is 2-3 days, then sir is out of station. You are all into.
My friend last time has given a oral commitment not to go for it.
Not sir.
My God, my.
Then I have no recovery.
Let him, my friend, take time. Fine.
That one speak 10th year. 10th next month, next week only.
It's come. He coming then.
22 until 10th September.
Definitely.
23.
May please minutes. Petitioner note is Indian Medical Association notes. And unfortunately, without the adjudication order, they have given a go by the long-standing principle of the doctrine of mutuality. Mutuality rules. Here, what has happened by virtue of an amendment, this particular matter, Lord, is now in before the Honorable Supreme Court, and for the DGGI, my Lord, on the DGGI's information, a particular inquiry was made with the Kerala branch of the IMA. Now, the Kerala High Court single bench, my Lord, decided that the amendment of section 7(1)(a) explanation, which by deeming friction says that notwithstanding any law, that the relationship between the club or member association and the person, my Lord, will be two different. If your Lordship would kindly see the language, my Lord, that section 7(1)(a). This was brought into effect by the Finance Act of 2021, but retroactively applicable from 1st of July 2017. Your Lordship, you see the explanation which they have added. Section 7 deals with scope of supply. 7(1)(a). The activities or transactions by a person other than an individual to its members or constituents or vice versa for cash, deferred payment, or other valuable consideration. Explanation. For the purpose of this clause, it is hereby clarified that notwithstanding anything contained in any other law for the time being in force, or any judgment, decree, or order of any court, tribunal, or authority, the person and its members or constituents shall be deemed to be two separate persons, and the supply of activities or transactions inter se shall be deemed to take place from one person to another.
So it's not retrospective.
It was given a retroactive effect. The Lordship would see the footnote with effect from 1/7/2017. Sorry,
From 1st of January 2022.
22, but no, 23. The word "and" omitted from so and so. It was given effect, my lord, from 1/7/2017 retroactively. Because clause AA was introduced with effect from 1/1/2022. Retrospectively applicable from 1/7/2017. No, in the footnote, your lordship would see, my lord, clause AA has been inserted and deemed to have been inserted. I'm sorry. I made it possible. So that's why, my lord,
That is why we were only one thing is inserted.
No, it was given a retroactive effect from 1/7/2017. That is why the DG. Sorry? Finance Act of 2021. Act one, my lord, I have also annexed that act, my lord. I have annexed that act, my lord.
Finance Act.
Finance Act.
Finance Act 21.
It's at annexure.
Page 70,
Five,
annexure 4. Annexure 4, page 70 also.
Annexure 5 at page 72, my lord.
This form is wrong.
My lord. So the period, my lord, here. 21. After the DGJ report. At page 72, I've annexed the act, the Finance Act. At page 72, by amending provision of section 108 at page 72, your lordship would get that deemed to be effective from 1st day of July 2017. At page 72, if your lordship. Annex against. So this matter was after the DGJ summons were issued, where before a challenge before the Honorable Kerala High Court. The Honorable Single Judge Bench of Kerala High Court held that the amendment is okay, but the retrospectivity or retroactivity attached was not correct. So the matter was taken to the division bench, and a writ appeal, laws, they have said that the amendment to do away with the doctrine of mutuality, which is a constitutionally recognized doctrine, which held through the 46th Amendment.
That was
as
because of 366-29A.
months. And so they said that even 366-12 capital A, where the services were introduced by virtue of an amendment, of 101st Amendment, had not changed the character. And this doctrine of mutuality is a constitutionally recognized doctrine which cannot be tinkered with by way of a legislation, unless there's a constitutional amendment. So that was the division bench, Your Lordship. That was a division bench judgment of the Kerala High Court. Now, this judgment of the Kerala High Court, my lord, was challenged before the Honorable Supreme Court, my lord. Discussions. So this was challenged before the Honorable Supreme Court by the Union of India. The discussion and findings, Your Lordship will get it at page 39. Sorry, ma'am? Has not been amended. Not amended. One. Only law 66-20 capital A was introduced.
tax on this supply by way of part of this service or any other manner whatsoever of goods being put or any other activity for human consumption or anything else, whether or not intoxicating. Yes, the supply of service is the tax upon payment or other valuable consideration. This is being put the
Money. Goods and service tax means good tax on supply of goods or services or both, except taxes on supply of alcoholic liquor for human consumption. But unfortunately, my lord, this concept of doctrine of mutuality, my lord, it was not brought in by way of a constitutional amendment. So that was the Honorable Kerala High Court's division bench judgment. No?
This is incorporated as.
Sorry?
This is incorporated as.
One.
You are representing.
I am representing the Orissa branch of Indian Medical Association. They have branches throughout the country, and they, my lord, have members, doctors as members, and they have various schemes which the doctors have enrolled themselves. And those schemes have also been discussed in the Kerala High Court at page 8, paragraph 3, if your lordship would see the various schemes and the objectives which the IMA, my lord, floats for the welfare of the members, especially the doctors. If your lordship would kindly read page 8, paragraph 3 of the Kerala High Court Division Bench judgment.
Yes.
Now, this matter, my lord, was carried by the Union of India to the Supreme Court, and I've given your lordship a copy of the Supreme Court judgment order, my lords, dated 25th of July 2025. Where, sorry,
Where is that?
Supreme Court order. It's a Supreme Court order.
German company.
German company has been referred about the retrospectivity.
But
It cannot be retrospective. That was the single judge's view. That was the single judge's view, overturned by the division bench. Or regarding input tax.
input tax.
Whether it
Cannot be retrospective.
Manoj, your lordships are correct. True, Manoj. And also, Vodafone's case has also been referred. And the Law Commission report has also been referred by the division bench of the Kerala High Court. And they have said that if it causes great injustice, because if you go 6 years down, if you begin assessments from 1/7/2017 for these institutions, you're causing a great harm and you're imposing a new burden on them. And so far as the Honorable Supreme Court has said, they have said that there can't be any recovery of the liability.
Recovery has been suspended.
Has been suspended, man. And in this case, not relying on the DGGI report of Kerala, my lord, the Orissa CGST authorities have begun, my lords. And the impugned order, if your lordship would see, depending on that DGGI order, my lord, of the Kerala branch, they have now initiated this proceeding, and they have not had, by virtue of this impugned order, my lord, they have
2.2.
Sorry,
2.2. Page 52.2.
Malons.
Information received from
DGGI Kerala.
which is journal
Malons.
and further developed by the officials of Director General of the GST Intelligence.
Malons.
Bhubaneswar.
So they have initiated it on the same report.
Membership collected from the member doctors.
Doctors by IMA Odisha branch. So they have taxed me, my lords. They have levied a tax of, my lord, of 39 lakhs, equal amount of penalty, interest. And that's how I'm before your lordship.
What practices were there?
But these
Holding on symposium, holding on whatever.
They have various schemes for members.
Now there are many schemes focused in the beneficial organization. So I'm the part of that scheme, so open for all.
But here, my lord, it's confined,
You are saying restricted to members.
restricted to the doctors who are members of the IMA. They have cardiological associations, they have medicine associations, they have ONG associations, my lord. And these doctors and other associations of doctors who are, my lord, beneficiaries of those various schemes floated by them. And in addition to it, my lord, they, by way of a contribution in this particular case, by way of a contribution from the Cardiological Society, they have a conference hall. Now they say, my lord, it's a service rendered to the cardiology department.
I'm appointed Union of India, madam, as the where's the challenge Union of India has to appear, madam. We are till now we have not obtained any instructions, so we are implemented.
Regarding the lordship, regarding the tax which has been implemented, not only fees has been collected, they have received rent and the lordship income from guest house and all, that should be taxable. Para page 61, para A, B, D. They are getting rent also on that.
Guest house for the doctors who have given, not the rent, my lord, it's only a service charge. They have, my lord, in their own way said it's a rent. This can't be given to any other person. Supposing your lordship would see Cutter Club.
Specified class of the payment. Can you make a segregation?
My lord, this is a service, my lord, it's not a rent. Supposing a doctor comes. Look, here, my lord, IMA house has some rooms which are given to doctors alone on payment of a service charge.
What is the service?
For the occupation, not for the maintenance of the room. All the clubs, my lord, they have, my lord, rooms which are given to members or affiliated members also. So that is not, my lord, renting of a immovable property. And it can't be a service, my lord. It can't be a business, my lord. For example, my lord, the Cutter Club has, my lord, various rooms, but they only allow members or guests of members or members of allied clubs, who are affiliated to Cutter Club. It's not open for one and all. I can't go walk down in like a restaurant or a hotel and have my food or stay in that particular room, Lord, unless I'm sponsored by a member of the Cutter Club and I'll be declared as his guest. So it is a service, my lord, rendered to the member, my lord, and I enjoy it because I am a guest of that member, my lord. But that will not be renting, that will not be akin to renting of immovable property. Similarly, my lord, I am a house everywhere, my lord, in the country, my lord. Now, supposing someone comes from Berhampur, has a conference in Cuttack. He books at a room at IMA House, Cuttack. And he is charged a nominal fee for that. So that will not be renting of immovable property or anything to do with a business which is run by IMA for giving this particular place, my lord, or collecting a maintenance charge from for the rooms, my lord, from its members. Because this will be restricted only to those who are doctors and members of the association. And Kerala case is a similar thing. Other than the memberships of the various schemes, they have other facilities which were enjoyed by the doctors, and members who of doctors who are members of the IMA. because I'm a misfit. And interest.
Reminded of that quotations which
It seems that there's now, so for us, the power to incorporate any provisions that in the doctrine of neutrality is to be within the constitutional power. But so far as the cancellation of the immediate act is concerned, so a particular retroactive or retroactively, relatively not its consideration.
By the single judge, by the honorable single judge. No, my lord. The division bench, my lord, held that the amendment, my lord, cannot be done without the constitutional amendment because a well-recognized principle, constitutional mutuality cannot be, my lord, tinkered with by virtue of a legislative amendment. And they have also upheld the retroactivity of that particular provision as held by the honorable single judge. That's why the Union of India challenging the entire judgment was before the honorable Supreme Court. And interestingly, my lord, the Kerala High Court order was produced before the original authority. No, it was recognized. That's the
It is inherent or integrated into a legal parlance is one. And the wise when you are testing it, that the power has to be tested, but that you get the state of the assessment.
So if I would download just reproduce.
That is the reason for
That's a reason. And interestingly, my lord, the adjudicating authority even though my lord, it's an all India statute, he says, my lord, this is not applicable to me because it has no precedence value. At page 61, he says, and he forgets about Kusum in Gods, and he says that the High Court is not binding precedent for another High Court. And that's how he rejects the Kerala High Court judgment and enforces the demand. At page 61, it is what you can see. But he says, your lordship, can you see the language? He cannot. Your lordship, kindly turn to page 61, my lord of the impugned document. Unnumbered. Lord, he is, my lord, I'll tell, my lord, with great respect, my lord. My lord, he is, my lord, he's caught
with that. So he says that I am within the jurisdiction, territorial jurisdiction of this court, so I am not bound by the judgment of another high court who does not have exercised the territorial jurisdiction
over me. And unfortunately, my lord, sorry, no? Jurisdiction of both of them, as well as the center.
This being center's specific statute. So
No, and the authority and the authorities and the authority, my lord, authority is the CGST authorities. They are the central authorities also. He says, sorry, operating in the state. Pardon? Unfortunately,
it is central operating. Cannot be challenged with any other high court. Cannot be challenged. It has to be challenged within the territorial jurisdiction, or which they exercise the power.
So getting my lord the long held principles that in a all India statute, like a siege.
That is a different. You are exercising power, can you challenge the order passed by HSP? The CGST order while sitting in the state of Odisha to a state of Kerala?
No.
Have to challenge it, so they also power. Then when I am under the territorial jurisdiction
Of the Odisha High Court.
why I should bind myself to the jurisdiction of another?
Off the record, my lord, unfortunately, he is, my lord, with the DGA report, he thinks that he can't move an inch and exercise his own adjudicating process. Because once a DGA report comes, he has to pass an order and a demand. Unfortunately, that is the unwritten principle. Previously, it was if a report comes from the vigilance department or the enforcement department, the officer was bound to pass a demand on him. Of course, I'm speaking from my own experience, not off the record. Otherwise, not he faces a departmental problem. So these quasi-judicial authorities, they just close their eyes to everything. If it comes from
Yes, the presidency, how the judgment of a high court of the central legislation is not binding on the Washington.
Definitely, yes. It's not binding.
Not binding.
Not binding. Why I'm saying so?
Very interesting.
Why I'm saying so, my lord? This in the present case is concerned. Let's see first prayer and second prayer. Second pair is confined to the assessment order issued by the appellate authority, issued by the authority concerned, and the SOCUS notice. The SOCUS notice itself disclosing about the provision of law, as well as the basis on which they have raised the demand. Let's see for a moment. I'm just 74. Yes. Yes. Yes.
Has you not invoked this provision to bring him within the purview of the taxation? Are you not? That is the source of your power. You are bringing this, and this has been held that it cannot be given a retrospective or retrospective
Effect.
If a judge, the court of a country has cited, will the quasi-judicial authority say, I am not bound by the benefit of the High Court?
They cannot say, I'm ordered.
Yes, say so.
No, my lord.
He said that he has been delivered by another court, which is not binding.
Binding on the present High Court, yes.
Only persuasive value, but I am not persuaded.
Sir, this is
Language.
answer and
Yes.
this is medical.
Yes, sir.
If it is in Kerala, the same set of services are dispensed with retrospectively by virtue of this term. But if it is in Odisha,
In Central Act, in Central Act, suppose to yesterday there is a Kerala, today Orissa, or tomorrow there is another state. It is not issue is that how there the High Court passed an order which ultra vires to the Central Act and it is binding on all the states. This is the question here.
Question is that the High Court, which has the jurisdiction.
The particular officer in their part, that I am conceding.
226 declared a particular provision of the central legislation as a risk.
Yes.
Now, can you tell me that can there be any other decisions taken by the other council?
Not in this case,
It's not about the other High Court, about only persuasive rights, but what is there to take there? Because the certainty law will be the rule of law, the virtue. Uniformity in law is also a virtue.
Well, I have examined the other another High Court is passed because in transport virus challenge the transport notification, Lordship, my Lord Justice Raman, ever to this Bombay High Court given a favor to the Union of India, but the Madras High Court passed an order against us. Our High Court basing on the passed order against us. Then there is a conflict decision is coming from different states. Yes. Yes. Yes.
That the information has come. And it says that, yes, you have a power to introduce, you can roll out whatever, but you cannot give it from a retrospective. Now he is going too far actually. He is going too far. He is saying that even a doctrine of mutuality is ingrained into a judicial system. The constitution may not come into play, but once these principles have been adopted, then it can render any legislative action to be otherwise. Which he says that one of the one of the advocates, we do not want to make any comment on that. Particularly me, I do not want to make that. But the bottom line of this thing is that when you give a particular provision to operate retroactively because the things which have already been done in past is now being included within it. Can you do it from a retrospective effect or from a retroactive effect?
Some time
I'll line of distinction between retrospective and retroactive.
My Lord is very technical.
We are very clear on this.
And no, my Lord is very technical thing. I have to examine henceforth.
This is what troubles me because it relates to a it relates to a retrospect or retroactive period. Because the mischief is shown to have been done from 2017. When the amendment has been brought in 2021. 22.
Yes. With 1st of January
22. Yes.
22.
The calculation is coming from 2017 onwards.
Yes. My brother always in the perspective of the taxation law. I am always in the perspective of the constitution. Take an instance of a dynamic subsection.
Yes.
When it was introduced in 1988. In UPS Kumar, the ethics code has said that it has a retrospective or retroactive in office. It says retroactive in office. This contains a several provisions which includes a provision of criminality if any dynamic transaction is held. If a transaction which was found to be valid as on coming in force of decision, if it is that is given a retrospective operation, the things which was valid is rendered invalid, and that too, if criminality or the criminal offense is perceived, and he will be prosecuted for that. Then the Supreme Court later on in 1991 says no, cannot be. Because you cannot render a thing which was legal at one point of time to be illegal by giving a retrospective operation and then set aside or overrule the witness Kumari's job and says no, from prospective, from the day when it comes into force, henceforth it will operate. It will not invalidate any transactions entered into prior date. The reason was simple. Here also they have whatever the services they have given. At that point of time, there was no charging system. They cannot charge them with tax. You cannot treat it as a member and the association two individual or separate persons. Then in that event, it will go back.
And I am putting a question to myself, is it not consequential matter?
Which one?
The assessment from 2017 onwards and the act is coming to 22.
Let us go now. The good sold does not say in 2016 when there was no GST.
True spirit is
2018 or 17 the GST came.
Yes.
And they say past transactions which have been made, they will come and you'll have to pay 18%. They are not charged from their customer because there was no law to charge.
My lord, the pre-assessment that in Income Tax Act, 132, or I am not expert in that way. Then that assessment will, suppose any evaluation is there. Yes.
The body is subject to the trust consumer.
Yes.
So with an option to have income tax credit benefit.
That's true. That's true. That's true. But here, why I'm saying, it is all the actions are consequential. Suppose
retrospective point of view.
that point of view, yes, my lord has.
That's why I say I reserve my comments on that. The doctrine of mutuality.
Mutuality, yes.
I do not know, I do not make any comment on that.
Let's say, give me some more time. I'll do it just 2 or 3.
So we have to be away from recovery.
But let's give some 7 days time, or the next week I
will also state the recovery.
Yes, sir.
In that, Bombay judge.
Yes,
Just to be more said, just complete the meeting.
well, Lasim pass necessary order, but what I'm saying that let me take an instruction thereafter. After 2 or 3 days, Lasim can keep it.
No recovery.
And only 2 days I'm asking, because only to take some instruction. But generally, I have idea to the department.
That perception of attachment or what?
Well, now, my lords, an order has been already passed.
Oh.
They can move for attachment.
That perception of.
Yes.
No, nothing.
Every
That
day.
part, nothing is included.
My learned friend, Mr. Padhi, my lord, he can't assure the CGST department not to recover.
No, Mr. Kedia.
Oh, yeah, Mr. Kedia. And, my lord, interestingly, the Telangana High Court, my lord, has also passed an order, my lords, staying, my lords, the summons. Interim order.
My lord may consider what I'm saying, because first time you was listed. Let me
Because
give
this
some
has
time.
now become a pan-India feature, my lord.
Really, I will consider the
Pan-India
court that if there's something the other court has
So
considered.
they have stayed the summons, my lord.
It is true. What I'm praying, my lord, which is the issue is related to the GST, some time may be given.
Yes.
Yes,
Has been stayed.
State.
Not recovery.
So the initiation itself has also been stayed.
Sunday will also short time.
And this DGGI will not report.
Today is first. Let's keep it to on 8th. On 8th or 9th, any time.
Chutti par 8th or 9th. At least let them have a peaceful Durga Puja holiday.
But yes. Yes.
No, hardly 2 weeks. No. The celebrations have already begun. No.
Between there is
Not here, Lords, from 14th.
Don't go.
From 14th onwards, Lord, the puja begins.
No.
Because there's a 16-day puja, Lord.
No.
Here, notice, Lord, it's a 16-day puja.
No.
Then, Lord, culminates with Navratri and.
This is.
Unless my learned friend Mr. Padhi, Lord, contemplates my Lord. I pray for
my lord, I am assured that instead of the department,
no, Lord,
they
I
will not
pray
go
for
for
an
recovery. Let's say fix 8th or 9th. I am assured that I'll today itself I wrote a letter to.
Yes.
And what you say, keep it?
He's talking about 8th.
8th or 9th.
Unnecessary. Let my learned friend take a reasonable time, Lord. Get instructions.
Let's say kiss to 10th, and I think by this time I'll be able to get.
Yes.
Then village.
Item 23 are done 10 September. Item 24, your lordship is 73 for village.
1 2 department will take care of it.
Item 25. Item 26.
Regarding non-constitutional GST.
Yes. And from this line, article.
Challenging the, it's a reach appeal, madam. Right, madam. Improved order is, phase 25 is the improved order. Right, madam. Saying that those candidates whose selection was subject matter of challenge have applied within the cutoff date, therefore the petition is devoid of merit. But it's like this, it lies in a very narrow compass. First you see advertisement, page 26. Just 1, 2 clauses I see so much. Kindly see page 26 advertisement.
So, within the original, you have acquired the eligible quality.
I have not acquired. Private opposite parties have acquired. But the last date was 30th.
Therefore, these the given, they were allowed to participate.
The lordship is correct, not sorry.
No, from the order, I have not correct or.
No, your lordship, with regard to corrigendum, what is the issue? In the original advertisement, there was a cut-off date. Right.
There are two types of advertisement basis. One is eligibility criteria, which should be as of the change is now. That is the last.
That's the last.
There are certain which is the state, and all of particular the results of
First one is the advertisement. As on that date.
As on the last date.
Last date.
So, if the last date is expected.
Not extended. Not extended. That's the point. The advertisement. Not kindly see. Corrigendum is at page 39. That is annexure 3. Yes. Just see one point. Yes. Why this corrigendum? Because like yes, only those who are eligible pursuant to the first advertisement.
No.
Kindly see note. Why? Kindly see note para 1. Why this corrigendum? The corrigendum is the advertisement was challenged in this honorable court on the ground that it exceeds 50% of the reservation quota. Now that this honorable court set aside that. Yes.
This is what you want. As a reservation.
Yes, only to that extent. Yes.
Augmentation of the.
Yes, variation of the vacancies only. No new candidate or permitted to apply. Yes, only those candidates who are eligible as on that cut-off date, as per the original advertisement, they were supposed to either apply afresh or not apply. Subsequent eligibility is not extended. That's the point.
Confirm jurisdiction.
That's the point. Vedanga Talukdar is clear on the point. Lord, he is assisting.
He has to approve the competent authority or competent. Yes.
That's it.
Item 29.
Your Lordship, I object that the impugned order dated 30th May 25, passed by the Lord in single judge in the WPC number 14,175 of 2025, be set aside on the following grounds. First, sir, it's the order dated 30th May 20.
The
30th May 25. Yes, Your Lordship.
5 seconds, let us go through the order. The matter. What's the fact of the case? What is the challenge?
Lordship, I've challenged the order of the Lord Single Judge.
Just say that you therefore one order of 23,022 by the Tribunal, which is confirmed by this court.
Yes, sir.
Also by the other court. So he says that the claim what you made is considered and rejected by a moderated petitioner.
Yes, Lordship.
No translation can be made to a original order passed by the Tribunal. That is what it says, and therefore once that's again finally you cannot challenge it again.
Your Lordship, that is order number 1, but I've also challenged the treat, the other 2 orders, that is the order dated 7th April 2025, and also the order dated 27th March 25 of the OP number 2.
The fact of because from the incident of the order and yes, the ambiguous.
Let's see the time.
That's why I was really wanted the order. He's unable to tell us that what has really happened. What's the fact?
Well, the fact is that, my lord, the present petitioner was working as a demonstrator in physics. Thereafter, he was promoted by the governing body to the post of lecturer, my lord. And thereafter, the petitioner approached the Education Tribunal to approve his post.
For approval.
Approval. And Lord Education Tribunal directed the Director Higher Education to consider his case. Now let's see, kindly turn to Annexure 5, that is the order passed by the Director Higher Education.
Rejected. Approval or accepting the approval?
Rejected. Now these
yes,
order dated 27/3/2025 at Annexure 5, page 49.
This is by which the director.
By the director.
Correct.
Now this order was challenged before the Honorable Single Judge.
This order.
This order.
Correct.
Honorable Single Judge told that as this order is passed by the Director Miller, it is to writ petition is not maintainable. Tribunal, jurisdiction of education tribunal.
This is what we wanted to mean.
Yes, Miller.
What it means by original order, not this order, again, finally, in the Supreme Court. This is what I really wanted to understand. In paragraph 3, says in terms of the order passed by the Tribunal on 23/3/2024 in GIA, so confirmed by this court and apex court. I do not know. The claim of the petitioner has been considered and rejected by order of 2027. I could not make a link to it.
This 13/5/2025 is 60. Is 13/5/2025. That is in the FAO.
Yes.
Previously, he approached the court, High Court directly.
Yes, Miller, in FAO.
FAO, first appeal order.
First appeal order.
Against the directors.
Against the director, my lord.
So he came in FAO 215 of 2020.
Yes.
There.
Page 60.
Because he's an authority and he has been delegated for the state education program.
Like this.
Correct.
So thereafter what? That went to.
No.
This is FAO order.
FA order. No, my lord.
That was carried by you before the Supreme Court.
Yes, my lord. And some other cases also, my lord.
Other case.
Other cases. And it was also dismissed.
No, but there was another FAO of
Yes.
2023.
Yes.
That was filed by the state of.
Oh, by the state.
By the state. That was by the state.
Challenging what order?
The order of this tribunal.
Tribunal. So why you are not going to the tribunal? If you can travel, is responsibility. That is ethical that tribunal is decided in the judgment of the judge. Go and file challenges before the tribunal. Before the single bench has said.
What will not say, judgment of this.
The coextensive with Article 246 like administrative tribunal. Education tribunal.
Yes.
This is under Article 323B. Not the.
Minute here.
24P.
It is under section, tribunal is constituted under section 24A, Miller, and 24 of Odisha Education. 24A.
Given to a tribunal, then go and challenge the order of the director to the judge. The High Court is only the appellate court.
But you are.
24C.
Yes.
But your lordship,
What is wrong in that?
I have submissions to make. Here is a case of 1999, your lordship. The petitioner was allowed to file this case in the year 1999. And the date of final judgment was on 6th July 2018. During this 19 years, there is no challenge to this petition, and the opposite parties, state opposite parties didn't oppose this one, where the petitioner challenged the order of the opposite party number 2, the director.
Where you can?
You will see this in this court.
Why you are appearing in person? Now, by virtue of the fact that in the Odisha Education Act, if Tribunal is constituted to take or to decide all the matters concerning the education institution, educational institution, teacher, officers.
Yes, sir.
That the High Court has been given a appellate power. If you jump the forum and directly come to the High Court, that is what the civil bench has said, that you go to the trial. Exhaust your remedy. It's not that you cannot. But you go to the tribunal, why you come directly under Article 226 for the single view?
Your lordship, I've already approached the tribunal. Already exhausted once and
Where you have exhausted, challenge the order of the director pass, which you challenged with the writ petition before the tribunal. Did you challenge that order?
Come to this, this one, 27/3/2025 order of Department of Higher Education.
yes, your lordship.
Answer 5, which is enclosed to.
Did you challenge it before the education, when the education tribunal?
Not yet, your lordship.
Then you go and challenge it.
So there, what is the final summary? The director has relied on certain decisions of this court, which of course, in para 30, and para 40. The article considered now after going to the reference of the claim of the application. As per observation made by the state education personnel, in their order 23 to 2022. You understand, does not find the interest to approve the promotion of appointment of the applicant in the school commission. Seven fourth with pay protection and release of further salaries components. Right? But denied. Then it will impact of premises stated above. And since the appointment is in receipt of 29 at full salary cost, with effect from 1997. Because the book of demonstrators.
Yes.
Under 28 order 1994, the prayer of the applicant or approval of the motion to this proceeding. So 7 do not have any merit for consideration and is rejected. This complies the order of Tribunal. Dated 23 to 2022. Passed in GIA number 70 2028, 80, right? So if you are assured by this compliance, you are even able to approach the.
You are still within the period of reservation, sir. Why don't you go and challenge?
But you let's say there are different orders of this honorable. There are different orders of this honorable court where the chief.
So now, whatever you want to cite, they can consider.
Sir, kindly listen to my submission first, please.
Yeah, appreciate. You may not have the knowledge of law or the nuances of law. You are a professor in physics, you know the physics theory and on this, but the problem is the jurisdiction. If there is already a forum provided in the law, then you surpass the forum and come back, you come to another court. That is the question.
But the circumstances under which I am submitting these submissions before your lordship,
Right.
that when I am at the fag end of my service, pushing me into the further round of litigation before the Lord and State Education Tribunal, as proposed by the Honorable Single Judge in para 4 of the impugned order dated 30th May 25, is not going to meet the ends of justice, your lordship.
No, that is, sir, again, I'm asking you, sir. The difficulty is that the jurisdiction you are invoking, bypassing the tribunal, which is already constituted for redressal of this grievance. That is the main issue. The High Court has said that why you are coming directly to me. You will go to the tribunal first, challenge this order, and then the tribunal decides again against you. Then you can come to the High Court as an appeal. That is a FAO.
But your lordship, I am citing cases where the petitioners have come to this forum directly. I am citing the case first one. The
objection must not have been raised by the other side, and the court also. Court must not have noticed this process.
So you consider representation? All these orders are considered representation?
My lord, at page.
He is referring all the orders. What are the orders? Consider representation.
Order is it?
Judgments and orders.
This is a judgment, your lordship. This judgment.
What?
Last
In what? FAO?
No, it is in the OGC. OGC, your lordship.
OGC. Earlier.
Yes.
Then the education tribunal was not constituted.
Your lordship, Educational Tribunal was constituted in the year 1998. And this is the case of 1999, your lordship.
Oh, I understand it may not be functional at that point of time, maybe constituted.
Subsequently, I am citing the case of 2005, your lordship.
My lord, it's already decided by this honorable court.
2005, your.
That's the jurisdiction of education tribunal will come.
Sir, the law is against you. You are not remediless. The proper difficulty is that which forum you should approach. And from this, it appears that you have to approach the tribunal. You have to approach the tribunal.
Your lordship, I am with the verge of superannuation. Next year, I am going to retire. If I will approach the honorable tribunal.
Can you jump the forum, sir? Our constitution, that the makers of the constitution have to introduce the hierarchical the system of courts. One has to approach the lowest court, then he can go to another higher court, then the highest court, and then the apex court. But one cannot straight away go to either of the courts. One has to follow them. Similarly, has to, in those physics, there are many theories and theorems. You have to follow, and then you reach. This is the same system it works.
But there's the order WA number 5556 of 2025 passed by this honorable court.
In what matter? FAO. You can approach the High Court, there is no difficulty. But when, if the tribunal passed an order against you, then you can approach the High Court, no problem. The court is not shut for you. But this is not the proper stage for coming to us. What is that order? What it says? In relation to another case, sir, that was a case of a work car. And those who do, they are not coming under the education. Ah. Sir, you are under the education department. And they are not. They are working in the municipality. There is no municipal tribunal.
Education tribunal jam pe se question tot.
Sir, think over it. We are keeping this matter as the first matter tomorrow. Think over it. I believe that will be second thought over it. No, we given the order is class C, but make it very clear so when you just go and challenge this order.
Item 49 will I had mentioned.
Item 51, my lord.
Item 49 I had mentioned before.
51.
Leftover items will be. Item 49 I had mentioned.
Item 51, my lord.
Item 49 also, my lord, I had mentioned first today. But we have to talk tomorrow.